Call Mr. Brad Rozzi.
Witness sworn.
Please state and spell your name.
Bradley Anthony Rozzi. Last name is spelled Rozzi.
How many different ways is that pronounced?
I don't want to get into that conversation, we'll be here all day, okay?
The press release, what day was that?
The day that, are you asking about the date that it was issued?
Yes.
I believe it was December 1st.
The day B.
There's a lot of dates run ing through my head, but I believe it was December 1st.
Was there an order in place before that time?
No, there was not, no.
Were there conversations with the court about not intending to try the case in public?
There were, yes.
Was the press release an attempt to do that?
It was not, no.
What was its primary purpose?
Well, first of all, it's something that was certainly thought out. It wasn't some, kind of random act that just occurred. There's a lot of strategy that comes with things of that nature and, in my opinion, I think really the first purpose that it served, from my point of view, is that it communicates to your client that you're behind them, that you're behind them in terms of the endeavor that's ahead in a case like this. So lawyers that are trial lawyers that know what they're doing, that are well trained, will tell you that, getting the client's trust and credibility is important, and so I think that's one of the reasons why, at least in my mind, that I thought it was a good idea. The second reason is maybe more unique to this case. You've got, from the very day that I entered an appearance in the case, I'm getting emails and phone calls, the office is inundated with those kind.
So one.
And so that's why we did it.
One per.
At least that's why I thought we did it.
One purpose was to stop random inquiries, correct?
Yes.
Another thought was to do it in a manner where you wouldn't be subjected to questions?
Oh, clearly, yeah, sure.
And then, were you I'm gonna approach and hand you Defendant's Exhibit T, were you familiar with the extent, when were you, when were you appointed?
I'm gonna say late October of 2022, estimating.
And were you familiar then with the extent of state agent-sponsored media presence and publications and press conferences and press releases?
May I review this?
Yes, you may. That states, Defense Exhibit.
Yes, I was generally familiar that a lot of these things were ongoing. To sit here and say that I knew about every one of them would not be accurate.
Is Defense T a summary of the dates and the communications from state-sponsored people?
That's what it appears to be.
What did you say?
That's what it appears to be.
Oh, move to admit. Defendant's Exhibit T offered.
No objection, Judge.
All right. I'll show T is admitted without objection. Defendant's Exhibit T admitted.
What then, was the press release an attempt to influence the public?
No, sir.
Was it a plea for tips?
I'm sorry, what was the question?
A plea for tips from the public, information from the public?
Well, I think that we were aware that that could be one of the, side effects, or I should say the result of that, but I don't know that we sat and had any real discussions about that in great detail.
Did, in fact, you get some tips?
Did we get some tips?
Yes.
Oh, yes, certainly.
Were any of them of any value?
Oh, very much so, yes.
And did you know that the Indiana State Police, sometimes with the...
I am aware of that.
So that happened? I'm sorry, was there a question before him?
You're asking me the questions, sir.
Yeah, I got interrupted. Did you have anything to do with the email to Woodson?
Mr. Woodhouse.
Woodhouse.
I did not. Well, I did not have anything to do with the initial email. I clearly had something to do with reporting it when I learned about it in March of 2023.
Did you get emails from Mr. Baldwin the day Mr. Westerman had, or no, did you get an email from, strike that? With regard to Woodhouse email, were both you and Mr. Baldwin fully cooperative and truthful to the court as that was discussed?
Yes.
With the Westerman leak, did Mr. Baldwin advise you the very day that Mr. Westerman confessed to him what he had done without permission?
Mr. Baldwin, Andy called me on the day that I believe that he learned of that and basically, reported that to me and then, yes, we followed up and decided we were gonna call the prosecutor and the judge.
Was that reported immediately to the prosecution and the court?
Yes. After I learned of it.
What did you say?
It was reported immediately after I learned of it for sure.
Well, right, but you learned of it the day Andy learned of it.
I believe that's true, yes.
Have you reviewed, during the break, the state's exhibit of the 5 pictures?
Yes, I had a chance to look at it during the lunch recess.
And were you present for Mr. Holman's testimony that he was presented with all of those pictures at deposition?
Sorry, could you ask that again?
Sure.
It's a little hard to hear and we've got a computer between us.
You want my hearing device they've been giving me?
No, it's fine, I can't really see you that well. Just go ahead and ask the question again.
Were you here when Sergeant Holyman testified those 5 pictures had been presented to him at a deposition at which you and Mr. Baldwin were present?
I was here, yes.
And over break, did you go back and contact the court reporter and get all exhibits that were presented to Sergeant Holman at that deposition?
I did, yes.
Were all 5 of those pictures presented to Sergeant Holman?
No, they were not.
Which ones were not?
Can I see the exhibit?
Strike that. It's under seal. Well, no, he's described what exhibit, I think states 6. I'm gonna hand you states 5, which has been admitted over objection. Can you, please, go through there and describe generally which photographs were not presented to Sergeant Holman?
Photographs 3 and photographs 4.
What?
I'm not going to talk about the details.
Well, neither have they, but 3 and 4 is not helpful, so there's a picture, and they've already said one of the victims that has blackout marks including a dash and a circle.
4.
Could you find that one?
That's the 4th page.
Okay.
Of this 5-page exhibit.
Was that presented to Sergeant Holman?
It was not.
Is that something the defense ever prepared?
No, I haven't and I don't believe Mr. Baldwin has, because I was part of those depositions and I haven't seen this.
So you've never seen that before?
I have not.
And to your knowledge, that picture was never given to the defense?
No. I literally just looked through the exhibits when I was at lunch and this is not one of them.
Okay. What was the other one?
It would be the 3rd page on this 5-page, in this 5-page exhibit, which is it's a handwritten diagram, it looks like almost maybe, I don't know, pencil or crayons or something.
Is that the handwritten alleged diagram of sticks and like a roughly drawn person with sticks placed around them or did that?
Yes, sir. Yes, that's a fair description.
Have you ever seen that before?
No, I've never seen this.
Was that ever presented to Sergeant Holman at the deposition?
It was not attached to the exhibits that I looked at that were given to us by the court reporter and I believe it was absolutely not.
Judge, I want to make a point of clarification. I think Mr. Hennessy has mischaracterized Mr. Holman's testimony. I had to look back at my notes. What I remember Mr. Holyman saying is some of the photos were from the deposition. Not all of them, so that's my recollection of the testimony from Mr. Holman. So I wanted to clarify that for the court, Judge.
Okay.
The record will speak for itself and I guarantee he described the circle part, 'cause I wrote that down in my notes with question marks, wondering what he was talking about, and then it came out later what he was talking about. Were you present at an unrecorded conference in chambers where the...
It was the gag order, I think that's what you're talking about.
Okay.
And yes, I was present.
And what was the discussion?
The basic discussion was that Mr. McClelland, myself, Mr. Baldwin was there, I believe, I'm pretty certain former White County Prosecutor Robert Guy, was present at that particular conference. I know it took place in Delphi, and I remember the discussion was prompted by the lawyers communicating to the court that we felt kind of handcuffed, because we had these orders in place and we didn't really know who we could talk to. Could you even talk to, a potential witness? Could you share any information with them, to try to determine their credibility or to corroborate information they were giving you, those kinds of things? I mean, I feel like even the prosecutor, communicated that it was kind of an odd space that we were working in and we just didn't really know where the fog lines were, so to speak, on the road, and the judge was kind enough, frankly, to have a discussion with us and try to define, where those lines were. And, my recollection of the conversation is, basically, Your Honor told us that, this is primarily intended to keep us from releasing information to media outlets, to having press conferences, to doing what I would consider kind of more traditional media-type relations if you were, I guess, in a case like this, and so that was the nature of the conversation that we had.
Was it expressly discussed that you could discuss evidence in discovery that you'd received with people you wanted to consult with for trial preparation?
I can't say that that was the exact discussion we had. I think it was more along the lines of if it's not the media, then it's okay.
Did you watch Barbara McDonald's report on court TV?
I did.
In watching that, did you notice stuff that she had that could not possibly have come from the defense?
Objection, Judge. I don't see what the relevance of that is to this hearing.
How's it relevant to the hearing, sir?
Well, it's the same response as before, but on this one I'm adding it could not possibly come from the defense, which it goes directly to the issue of what defense did provide, what defense didn't provide, and he's prepared to testify he saw her with stuff that could not have possibly come from the defense, and he's testifying on his own behalf on a...
Overruled.
Do you want the question again?
I saw her, holding what I would consider part of a report and talking about it openly, and it's certainly something that I knew was part of the discovery and it wasn't provided by me, and I'm fairly certain it wasn't provided by Mr. Baldwin, because both of us were pretty surprised that she was talking about this openly, to the entire viewing public.
And wasn't there something about sticks?
Well, it was the Purdue report is what it was.
Okay. Anne.
I'm not even sure we had it at that point. I could be wrong, but if we did.
I'm gonna approach you and hand you an envelope that is marked, flash drive, Barbara McDonald interview on court TV, do you recognize that?
I do.
And was that preserved on a flash drive?
Yes.
Look inside, tell me if that's the flash drive.
Yes.
Thank you. Move to offer Barbara McDonald on court TV, Defendant's Exhibit U offered.
Judge, same objection to relevance, and also, I believe it's hearsay. I haven't watched the report, but if it's going to be her testifying about what she's gotten and what she believes is leaked, I think it applies to hearsay, Judge.
Any response?
Same response.
All right. IYLL show that you is not admitted as hearsay.
Are you familiar with the Indiana Public Defender Counsel's performance?
Generally I am, yes.
And have you lived up to them?
Yes.
And is brainstorming and war rooms for trial prep common within criminal defense counsel and considered essential to trial preparation and adequate representation?
It is.
And then, are you familiar with the Indiana State Police typical protocol for investigations such as the one at issue here?
I actually do have some knowledge of their general protocols, yes.
And how do you have that?
Because I've represented state troopers that have been accused of crimes. I have a brother who's one of the chief detectives at the Peru Post and I talk to him routinely. I'm very familiar with what goes on in the state police, investigative ranks, so to speak. And a lot of friends and a lot of other clients that work in that field.
And what would be their normal protocol for an investigation of leaks by defense counsel in a criminal case in which they were involved?
Well, I've never been involved in a case where there was an allegation of a defense counsel leak, but I've certainly been involved in cases where there were, let's say, ethical issues at stake, and they typically farm those out to other posts. In fact, I had a meeting with one of I think they call them their internal investigative unit or whatever. I actually had a meeting a week or two ago with a client with an internal officer, and so they're typically farmed out to other posts.
Thank you. Without getting into them, are you Ami liar with, from your review of all of the discovery provided on this issue that they've given us over 100 pages of Fortson stuff, they've given us Westerman stuff, Cohen stuff, are you aware of other leaks that cannot possibly be connected to the defense?
Objection. Judge. Relevance.
Just in general. We're not gonna get into it, but whether he's aware of it.
I think you've made your point, Mr. Hennessy. I'll sustain the objection.
Oh, did both you and Andy, it's in evidence, you wrote a letter to Judge Gull, the state introduced that into evidence.
Okay.
You recall that?
Regarding the Westerman situation?
I can't remember.
Yeah, I know I wrote a letter to her in the fall, I'm not sure. I might have done more than, I might have written more than one, so.
Are you positive that you and Andy cooperated fully with candor and honesty to all inquiries by the court regarding anything at issue here?
Yeah. I sat down with Officer Rector and signed an advisement of rights and answered every question that he asked me immediately after we heard of all this.
That wasn't the question. The question was with the court. Any questions asked by the court, did you respond? It's Rule 3.3 of the Indiana Rules of.
Yes, sir.
That's all I have.
Mr. McClelland.
Thank you, Judge. Mr. Rozzi, I think you said this, but I want to make sure I'm clear. I want to start back in the beginning with the press release. You concede that there was an in-chambers meeting before you and Mr. Baldwin made the press release where you told the court, Judge, there's no reason to issue a gag order. We're not about trying this case in the public or something to that effect.
I think it was not that. There was a discussion in chambers, generally speaking, which I, frankly, think you prompted about trying this case in the public. I do acknowledge that.
And in that meeting you said, Judge, there's no need, we don't consent to the gag order. But there's no need for that gag order. Do you recall that?
I think that's a fair summary of the conversation we had.
And then after that is when you agree that after that is when the press release was put out by you and Mr. Baldwin?
Yes, sir.
Okay. The email that Mr. Baldwin sent to Mr. Woodhouse. When did you?
I found out about it on the day that we reported it, which I think was some day in March. I think what I later learned was that it occurred maybe in December and, frankly, I've already forgotten the date on that, but I found out about it in March and then reported it immediately thereafter.
And do you know, W as the email sent before or after the gag order was put in place by this court?
I don't, Mr. McClelland, I really don't know, I'd have to look at the dates.
And do you agree that, perhaps not all, but some of the photos that were leaked by Mr. Westerman are photos that the defense created from discovery provided by the state?
Well, I don't know exactly what Mr. Westerman did. You know, I wouldn't know Mr. Westerman if he were sitting in this chair next to me, okay? So I don't know what he did.
So the answer is?
So the answer is no, I don't know.
Okay. The photos that you saw today and State's exhibit, were those created by defense, specifically the side-by-side photos?
Those look familiar to me from the deposition of Mr. Holyman from early August, they do look familiar. I mean, of course, they're kind of screenshots of screenshots, so it's kind of hard for me to sit here and say that's exactly the document that we prepared. I'm not trying to get overly technical, but, they might have been reproduced.
Okay. So I guess what is your answer? You don't know or?
I'm not really positive.
Okay.
I don't know.
Okay. I don't have any other questions, Judge. Thank you.
Mr. Hennessy.
Can I have a minute?
Sure.
No redirect.
All right. Thank you, Mr. Rozzi. You may step down.